discussion being focused on Article 5 raises some tricky and difficult issues, hence why I say it's so tentative and it hinges on context. The same point would apply, but it would be potentially much easier for the court to approach this, I think, through the lens of the right to freedom of movement under Protocol 4 of the Convention, Article 2. The UK has not ratified that protocol, and I would welcome it doing so, and this situation, I think, underlines the need for the UK to do so. Thank you very much.
Thank you very much, Stuart, and thanks everyone for joining us. I'm delighted to be part of this panel, and thank you very much, Stuart, Constantine, and Alan for inviting me. I want to add a twist to our discussion of human rights curtailments and derogations in the context of lockdown and associated measures, because I think the conversation around coronavirus and human rights can become a little bit unduly skewed if we predominantly ask the questions of what rights restricting measures states can or ought to pursue in response to the pandemic, and how these should be best implemented in line with human rights, whether by derogation or qualification. I want to talk about positive obligations under the European Convention on Human Rights, notably what states are duty-bound to do for us in the context of this pandemic under positive obligations to protect our life and bodily and mental integrity under the Convention. And I want to clarify two important dimensions of positive obligations that I think are vital for recalibrating some of the exceptionalist discourse around what states are doing and what they ought to be doing in the current crisis. I think it's important to do this because states' duties to protect life in particular have been actively invoked during this period, notably to justify extensive coercive and or rights restricting measures in response to the coronavirus pandemic. So the first point I want to underline in respect of positive obligations is that states bear positive obligations to protect us rather than coerce us. The second point I want to highlight is that states' positive obligations do not extend to duties to act unlawfully within the European Convention on Human Rights. And I think it's vital that these two principles shape our human rights response to the current crisis, particularly that they shape our response to an exceptionalist rhetoric that unduly centers rights restricting measures as the measures through which coronavirus will be fought. So on positive obligations, protective orientation, positive obligations are, as the European Court of Human Rights has repeatedly underlined, duties to take reasonable and adequate measures that are orientated towards providing practical and effective protection of rights. The overarching goal is therefore protection from harm. That positive obligations are duties to protect may seem fairly obvious, but I think it's crucial to emphasize, and this is because, as Leora Lazarus highlighted in 2012, duties to protect are all too often and all too readily translated into duties to coerce, to mobilize the sharp edge of the state and its law enforcement mechanisms as purported means of delivering protection, to send the police to deal with the matter, to call the cops, to put it more simplistically. Of course, some coercive measures may be considered reasonable and indeed necessary to protect life and bodily and mental integrity. Consider criminal law provisions and enforcement in respect of domestic and sexual violence, for example, though even there is persuasive criticism of the effectiveness and efficacy of the criminal law in truly protecting potential victims and survivors of such violence. For the purposes of our discussion, I'd say that it is important at least to acknowledge that even where coercive measures might be deemed necessary, they are usually not sufficient to provide effective protection. This is obviously the case in the context of this pandemic. Of course, it is tenable that states bear some positive obligations to take certain lockdown measures to contain the spread of the virus. But such coercive and rights-restricting measures are not exhaustive of the state's positive duties to secure practical and effective protection. States bear general duties to set up adequate laws, mechanisms, and structures for protecting life and bodily and mental integrity. They bear operational duties to protect persons who face a real and immediate risk of serious harm, of which the authorities know or ought to know about. And they bear procedural duties to investigate credible complaints or suspected incidents of arbitrary loss of life or torture or ill treatment. States should, for example, provide adequate protective equipment for persons who are put in harm's way, as Elizabeth Stubbins Bates has highlighted in a recent blog post. And states should also deliver effective disaster management planning. They should bolster healthcare provision, including emergency healthcare provision, and they should secure effective access on a non-discriminatory basis to essential goods and services. States must also take reasonable and adequate steps to alleviate risks that may arise or be exacerbated by lockdown measures, such as risks of domestic violence or destitution. It's relevant to recall in this regard the UK judgment in Limbuella, which highlights that the right not to be subjected to torture or inhuman or degrading treatment is violated when somebody is, by the deliberate action of the state, denied shelter, food, or the most basic necessities of life. This entails that initiatives such as the provision of financial support for people who have lost their source of income are not only sensible policies, but amount to the discharge of obligations under human rights law. Additionally, as the Strasbourg Court has frequently highlighted, states' positive obligations are enlarged or amplified in respect of vulnerable persons or persons who are deprived of their liberty. And I think it's imperative that we keep a very close eye on how this is reflected in state policies and practices regarding persons who are or who are rendered vulnerable, marginalized, or dispossessed in the context of this crisis. In order for the positive measures taken to be capable of delivering practical and effective protection, they have to also be responsive and tailored to the circumstances at issue and the particular risks that arise. And because it is not just what state authorities knew, but also what they ought to have known that shapes positive obligations, states must take positive measures that enable them to ascertain and accordingly to respond to the changing circumstances and relevant risks, including risks that are triggered or worsened by the lockdown, notably the heightened risk of domestic violence. It is worth noting that investigative duties are likely to be of substantial significance in relation to knowledge-driven responses, both during the pandemic and in its aftermath, particularly for putting an end to abuses or misjudgments or other failings, or ensuring they do not happen again. My second point will be put more briefly. It concerns the legality limitation on what states may claim to be duty-bound to do to us, whether by means of derogation or qualification or otherwise in the context of the pandemic. And this is a little bit of a flashback to part of my response to Stephen Greer that Stuart kindly mentioned today. So the point about the legality limitation on positive obligations is that positive obligations are not only meant to be shaped by protection rather than coercion, they are also fundamentally bounded by the limits of what is lawful within the European Convention on Human Rights. What this means is that while the imperative to protect individuals from grave harms may justify or even compel a range of extensive and even sometimes exceptional measures, it does not require or give license to states to act in ways that are unlawful within the convention. In concrete terms, this entails that positive obligations emphatically do not include duties to act in ways that are conclusively unlawful under the Convention, such as inflicting torture or inhuman or degrading treatment. With respect to rights that may be lawfully departed from, whether infringed or derogated from, positive obligations may only extend to measures that amount to necessary and proportionate infringements on those rights, or measures that are strictly required by the exigencies of the emergency situation in circumstances of lawful derogation. So in conclusion, many states might be quick to appeal to being duty-bound to save lives in justification of sometimes unprecedented coercive measures. In this context, we must not lose sight of positive obligations' protective orientation, and we must hold states to account in respect of their provision of practical and effective protection of life and bodily and mental integrity. And this can be quite an exacting standard. It's also vital that we remember that positive obligations do not extend to duties to act unlawfully towards us under the Convention. So while we should vigorously hold states to their obligations to protect us, I think we should all employ rigorous and continuous vigilance to trace and hold states to the limits of what they can properly claim to be duty-bound to do to us rather than for us. Thank you.
Thank you, Stuart. It's a great pleasure to be here with all of you, or of the 100 or so of you. Just a little note that this is also live streaming, as Stuart just said, on Facebook and as well as on YouTube. So if you're unable to reach us through Zoom, you could also be able to connect with us from other places. So greetings from Berlin. We have been in a lockdown, or I have personally been in a lockdown for the past 4 weeks in Berlin. So in self-isolation, homeschooling, remote working, and a whole lot of it. So this is week 4 for us over here. As you may know, in Germany, there is no state of emergency, and there are no derogations from the ECHR or from the ICCPR. There are some states, Germany is a federal state, in some of the states like Bavaria, there are local states of emergency. But I speak to you from Berlin, where there's not a state of emergency or derogations from the state itself. So one of the things that I wanted to interject in this debate is the comparative perspective, as Stuart highlighted, for a couple of reasons. One, I think this is the first time ever that we're actually able to comparatively study derogations in international human rights law in real time, in the sense that, you know, there's always one state derogating because they have some sui generis extraordinary circumstance. A couple of years later, someone else derogates for something else. At the moment, we have a threat that is very identical in each and every jurisdiction. And we are looking at the world, and we're able to, in real time, understand the variations and how they react in different ways. This is an unusual, a really unusual situation for researchers like us. So, as you know, everyone says that life will never be the same after the COVID pandemic. Everything we do is going to change. My hunch is that our understanding of the derogation regime may be one of those things that may also change because of the pandemic and its real-time implications. So what is interesting here is that there is a significant amount of variation in how states have responded, whether, as has been highlighted earlier as well, whether states have derogated or whether they've actually not derogated from the Convention or from the Covenant on Civil and Political Rights or from the European Social Charter or from the Inter-American Convention on Human Rights, for that matter. At the moment, we see that Martin Scheinen and Opinio Juris did a really nice blog post and listed about 10 states in South and Central America. And with the Serbian derogation, I think in the Council of Europe zone, we have 9 derogations as of today. So a lot of variation. I'd like to think, hopefully collectively a little bit, and very tentatively, I have to say, because life of an academic in homeschool and remote working is a challenging life, as you may all know. So this is a tentative collective thinking. I'd like to think about 2 questions. One is, what explains this variation? Some Council of Europe member states have and others haven't derogated. What explains the global variation in the Americas, in Asia, or elsewhere? We can also ask a more of a global variation question. So what could be some of the reasons that some states are saying that there is a state of emergency, they have to suspend certain rights for a certain period of time, that is the definition of derogation, and others are not doing that? But as Stuart highlighted, in effect, what they're doing in practice is quite similar to one another. So with or without derogation, they are, we're all in one lockdown or another. So maybe a couple of potential explanatory things that we can think about. The first one is the international legal framework about derogation. We don't have a unified framework about which treaty you can derogate from, right? So some treaties allow for it and others don't. Some are silent about it, particularly the African Charter on Humans and People's Rights is incredibly unusual, perhaps because it covers a very similar range of rights to other regional treaties. It doesn't have a derogation regime. The European Social Charter in Europe, which is an economic, social, and cultural rights treaty, does have a derogation regime under its Article 30. So international human rights law has derogation regimes, but not everywhere and not in the same way. So I think this may explain that we are not getting a lot of derogations from Africa, or you can say the speed of the pandemic hasn't arrived Africa yet. Not a lot of the states are doing it, but we get it more from Americas and from Europe. But of course, the second aspect of the legal framework is that when we have a derogation regime, the articles of the ECHR or the ICCPR or the Inter-American Convention, they say that states may derogate. They don't say states must derogate. So, and this is a really odd formulation, which means that states do not have to necessarily derogate, even if they're facing a state of emergency threatening the life of the nation. And some of us over here are experts on this issue from another perspective. Some states, when they engage in extraterritorial military action, for example, the United Kingdom is the most well-known example, they do not derogate from the European Convention, and they might say we don't have to do that. And that was the Hassan versus the United Kingdom case in the past. But I think the second really interesting point is that domestic legal frameworks that actually enable derogation are wildly different from one another. Incredible variety. Take the examples of Latvia, Estonia. These are the derogating states from the Council of Europe system. The legal systems are much more enabling. The constitutions and the convention derogation regimes are much more in sync with one another. They are better harmonized. Institutional procedures are really nicely set out. It is easier to derogate for Latvia than it is for Germany to derogate from the European Convention. I would argue. In some states, for example, Austria or Sweden, there are no very clear mechanisms of how they could even declare a state of emergency, and people usually associate derogations with a state of emergency. In Italy, you can't declare a state of emergency in case you don't have a situation of a war. So this really brings us into a very interesting situation where the derogation regimes, the way that they're regulated in domestic constitutional law, are wildly different, not only within Europe, but also around the globe. US is a well-known example. You can't derogate from the US Constitution either. Now, the third, I think, the point which we may really consider in terms of these variations is in some states, there is, and Ed, I think, spoke to that a little bit in the beginning, there's actually a de facto state of emergency regimes that are actually in place. So what do I mean by that? Some countries have already pre-existing highly restrictive rights regimes. So if you have a very restrictive rights regime in place through your domestic legislation and or through your constitutional legal framework, you don't need to declare a state of emergency, and you don't need to derogate because your regime is incredibly restrictive in the first place. One of the reasons that I've been thinking hard about this is the situation in Turkey. In Turkey, you don't need to derogate from the convention because there has been a lot of laws that have been written into ordinary laws from the time of the state of emergency, which have now become ordinary laws, empowering, for example, provincial governors to ban travel from one city to the other. And if you have those laws, you don't really need to do anything extraordinary because the extraordinary is the ordinary in that jurisdiction. And of course, the fourth one, and to my mind, the fourth explanation has received the most attention in recent writings, perhaps, is political opportunistic behavior that says, some people use the virus to actually usurp power or to expand the powers. So they use the derogation regime as a tool of their own sort of, to increase their own powers. I do understand that. I understand that comparatively, there's lots of references made to Hungary in particular in relation to this example, or to Israel's stopping of the trial of the prime minister that has been the caretaker prime minister for corruption charges. Of course, these stories are also there, but I don't think that this is the only explanation as to why some states have derogated from the Council of Europe and the others from the Organization of American States. So these four sort of explanatory variables, I think, help us to think very differently about derogations. From which regimes you can derogate, why this is a permissible regime, why some states make it easier and the others much harder to actually use suspension as opposed to everyday restriction. So what kind of comes out of my comparative thinking about these issues? One of the first things is that I don't think that each and every derogation from the ICCPR or the Inter-American Convention or the European Convention on Human Rights can be bad news. We can't say that every derogation is a terribly bad incident. In that sense, for example, I have read some tweets from the Council of Europe spokesperson who was saying that we don't encourage derogations. Everything that has to do with this pandemic is covered in the convention and so on. And I'm not so sure that we could just say that derogation bad, non-derogation is good, because this only assumes that there's only one definition or one reason for derogation, which is to put together an abuse of rights regime. So if we think about reasons in a comparative way, I think we need to think about other situations and so on. The second thing that is my takeaway from my very tentative comparative analysis is that derogation regimes are not necessarily sort of more rights restricting than non-derogation regimes. Now, it has already been highlighted that in the UK there is no derogation, but a very, very seriously extraordinary rights restricting regime. So this sort of knowledge that derogation is always super, super worse than sort of restriction of rights in a hyper proportionality test, I think it has to be also thought through. Derogations do other things. They signal that people are taking things seriously. They are temporarily putting some arrangements together. They're thinking about it. They're communicating about it. So some derogations may actually be very good derogations and not necessarily bad derogations. So this is sort of where I've come looking through the different measures that have been taken around the world. So my two takeaway points for me is that I don't think that the regimes that are now currently governed in 2-week or 3-week derogation regimes are necessarily going to lead to worse rights outcomes. And I think that some regimes that haven't had derogations, like the one in Turkey or in the UK, necessarily are going to have better human rights outcomes. Thank you.
Thank you very much, Bashak, for your interjections there, and certainly some very interesting comments in relation to this kind of binary distinction between derogations bad, non-derogations good, and some of these ideas that we have of some of the other signalling benefits that we can get from having derogations as well. I'm sure that our next speaker will wholeheartedly agree with some of those interjections. So without further ado, I would like to pass you over to Dr. Alan Green for his comments. Alan.
Thank you. Can you hear me okay? Great. Right. So yeah, welcome to the new normal. And I think that one of the, obviously lots of strange things have happened in recent weeks. And one of the strangest things that is happening from my perspective is I actually find myself arguing in favor of the existence of a state of emergency, because very often on my research on Article 15 and derogations, I'm very skeptical as to whether a threat to the life of the nation actually exists. And we're finally in a situation where I think, yes, there is absolutely a threat to the life of the nation. And we have a dispute as to whether actually we should use Article 15 here. And ultimately, I think this dispute, it picks up on some of the things that Bashak was talking about. It's this idea of whether business as usual models of keeping calm and carrying on are the best ways to approach crises from a human rights perspective versus actually clearly identifying that the ordinary parameters of normalcy no longer exist and we need a state of emergency. We need to somehow quarantine these exceptional powers to exceptional situations. And I think that's ultimately the kind of dispute that we're having at the minute. And that's the bit that I'm going to try and focus my talk on. So what really we're looking at is the clash between business as usual versus emergencies, a clash ultimately between de facto states of emergencies and de jure states of emergency. And as you might be aware of, I'm very much in favor in this instance of a de jure state of emergency. And my reason for that is because states of emergency are supposed to act. Obviously, you know, we're familiar with the harmful effects that emergency powers can have on human rights. And that's very well documented, not just human rights, but other aspects of constitutional law, like the separation of powers, etc. But they can also potentially have a shielding effect from a human rights perspective. They can protect human rights by limiting exceptional powers to exceptional situations. In contrast, this idea of business as usual, of keeping calm and carrying on the face of it, they sound like they do provide better protection from human rights. The famous statement from the US Supreme Court just shortly after the end of the Civil War was that, you know, as Bashak mentioned, there's no provision for a state of emergency in the US Constitution. So we had the US Supreme Court come along and state, oh, that the same law in war the same law in peace applies in war. And that makes it sound like, okay, we're going to have great, lovely human rights protections in a time of war as we do in a time of peace. However, what we actually see is in reality, the opposite happens. And actually human rights in a time of peace end up being recalibrated downwards. Those same standards are expanded in order to accommodate what is perceived to be necessary to confront the threat. The idea that the Constitution is not a suicide pact. So we stretch the meaning of the Constitution in order to accommodate these exceptional situations. And this is famously encapsulated by the US Supreme Court Justice Robert Jackson in the Korematsu case, where he states when we expand the parameters of normalcy to do this, that principle then that we will allow these exceptional powers without a derogation lies about like a loaded weapon, ready for the hand of any authority that can bring forward a plausible claim of an urgent need. Every repetition embeds that principle more deeply in our law thinking and expands it to new purposes. And so this business as usual approach that the US Constitution took did not stop the detention of US citizens of Japanese descent for the duration of World War II. Business as usual did not provide any additional level of protection. Now, of course, states of emergency are absolutely dangerous from a human rights perspective. And if you look at the Irish state of emergency under the Constitution, it basically states that nothing in this Constitution can limit state power in an emergency, with the exception of reintroduction of the death penalty. But that's the closest you kind of get to a carte blanche in terms of the power that's enabled. But the European Convention of Human Rights doesn't give states carte blanche. It requires that measures are still taken, that they have to be proportionate to the exigencies of the situation. Further, non-derogable rights are still in play. And Natasha's excellent blog post in Strasbourg Observers that's just gone up, talks about the positive obligations that arise from Article 2 and Article 3 that are non-derogable. So they're still going to be in play. So there is sufficient protection, I think, there as a result of Article 15, and necessary protection too. And I think we should use Article 15 rather than try this business as usual. So my talk here kind of is based upon a blog post I did for Strasbourg Observers. And quite a lot of that post homes in on Article 5 and whether Article 5 is potentially being impacted upon by these measures. For time reasons, I'm not going to go into that. But what I will, but it is available if people are interested in reading it further. What I will say is obviously there are mechanisms in which Article 5 could potentially be interpreted to accommodate certain lockdown powers or expanded forms of detention for the pandemic. Article 5(1)(e) being one of those for the lawful detention of persons for preventing the spread of infectious diseases. But I set out an argument as to why that's problematic. But we can see how that could be used to accommodate this exceptional situation that we find in. I think the biggest risk as well is that we don't say that they're deprivations of liberty at all. They're simply restrictions to movement. So Article 5 isn't even triggered. But as Ed highlighted, a key problem with saying, okay, it's not Article 5, it's a restriction, it's not a deprivation, we can accommodate it under freedom of movement in Article 2 of Protocol 4, is that it's not been ratified by the United Kingdom or Turkey, two countries that have a long experience of counter-terrorist powers. And if we allow this principle, this idea of an exceptional, this principle of an exceptional situation being used to accommodate these exceptional powers without a de jure declaration of an emergency, we cannot solely limit that to a pandemic, particularly so if we say it's a restriction rather than a deprivation of liberty. There's absolutely nothing, therefore, stopping similar measures being used or being, represented as being necessary to deal with more, or I suppose less objective threats, for example, things like terrorism or other national security emergencies. And this raises a further issue. And it might sound far-fetched, particularly if you think, okay, we're in a nice, stable Western European country. But a key problem we have with emergencies as well, and particularly, one that we all agree that the measures are necessary to deal with, is we might agree with that at the outset of an emergency. But the problem arises particularly in identifying the end of an emergency. And I kind of feel like we're all in the same conditions that judges find themselves in at the outset of an emergency. We want to defer to politicians. We want to say that these measures are necessary. And as a result, we want to say they're compatible with the ordinary parameters of human rights, because we don't personally want to say that, okay, that these measures are potentially harmful from a human rights perspective. I think it's much more important to say that actually, yes, they are harmful and acknowledge that, but try to emphasize that it's temporary. And this is particularly important because identifying the end of an emergency, whether de facto or de jure, is so problematic. So we have a pandemic at the minute. However, we also have had a knock-on economic state of emergency arising out of this. And, already we're in a situation where the objectivity of so-called necessary measures taken in an economic crisis are incredibly problematic. Economic crises, in turn, are fertile breeding grounds for social unrest, which is where you get quite egregious human rights abuses. Ireland, just for example, released its unemployment statistics today. I think they're up at 26%, the highest they were at during the 2008 financial crisis was, I think, 16%. So these are ample conditions in which you can get exceptional human rights abuses. And it doesn't take much imagination to see how these lockdown powers could be expanded and extended to these other more problematic emergencies. And ultimately, I think, if we are to think about what the dangers of emergency powers are, I'm absolutely not trying to downplay the dangers of de jure emergencies. But it's important to know that Article 15 doesn't create a Carl Schmittian state of exception. Article 15 doesn't create, the kind of state emergency that we're seeing in Hungary. Okay, it's different. It's not a state of exception. It's not a zone of beyond law. The real story of emergency powers in the 20th and 21st century ultimately are is the dangers of de facto emergencies, of these powers, these exceptional powers that originally looked as exceptional becoming permanent. And this ultimately entirely defeats the justification of these powers. Okay, if they're temporary, they're unpalatable, but they're temporary. It's a temporary sacrifice. And once the threat is defeated, then the measures will recede. If they're not temporary anymore, then all we're left is with their draconian nature. They're no longer defensive. They end up being transformative. We have permanent emergency powers, as Basak mentioned, Turkey being a key example, the UK being an example, France as well. And I suppose, ultimately the biggest worries that we have, the most concerning cases from a human rights perspective in the context of emergency powers are cases like Korematsu, are cases like Liversidge versus Anderson. These aren't de jure states of emergency cases. And refusing to call a spade, in my perspective, doesn't make it any less of a spade. So just to finish off, as to whether I'm being somewhat naive in thinking perhaps that Article 15 can have a shielding effect or can quarantine emergency powers somewhat. I think it's precisely because I'm not naive. It's precisely because I am skeptical of the European Court of Human Rights' ability to stand up to governments and say that these measures are not compatible with the convention or upholding certain human rights standards. That's exactly why I'm saying that states should derogate now, so that in the event that the measures are called before the court and the court ultimately upholds it and does it so in maybe a problematic manner, at the very least that exceptional jurisprudence or that problematic case can be quarantined, okay? And that we can say that that case does not apply in this instance, that we have a very clear parameter drawn around that case that says it's an Article 15 case. It might apply in other Article 15 situations. It absolutely does not apply in non-Article 15 situations. And without that clear limitation, I think any problematic jurisprudence that is highly probable of arising as a result of these measures will not potentially seep into other areas of normalcy. So I think I'm over my allotted 10 minutes time, so I'm going to leave it there, and I'm sure we'll have loads of time for questions, and I'm sure Constantine's going to have a lovely response for me as well. So thank you.
Thank you very much, Alan, for those introductions. Originally when this was mooted as an idea, the suggestion was that we would have an academic rap battle between Alan and Constantine, but unfortunately Alan declined that, so I think we'll just have to go directly to Constantine for his one-way contribution to this rap battle. Over to you, Constantine, to get your comments.
Well, can you hear me? Yeah.
Yes, go ahead. Yep.
I'm not too sure about my rapping abilities anymore, but I will do my best. Thank you very much. And I have spent quite a bit of time trying to arrange the live stream of this webinar to Facebook, and I miserably failed. But thanks to Stuart, we have a live stream to YouTube. So please follow the link on YouTube. Now, First of all, thank you very much for everyone. And we reached 100 participants like in 5 seconds after the opening after the admitting people to this conference room. That is fantastic, and thanks for joining us in these challenging and difficult times. And we highly appreciate it, and we're really looking forward to your questions and comments at the end. Now, I want to set my main argument straight away. And I think that, and from my blog post on Strasbourg Observers, it is quite clear as well, that I think that declaring the state of emergency is neither necessary nor desirable in the current situation. And I think that, of course, I'm not arguing that we are not living in the de facto state of emergency. Of course, we do. And it doesn't mean that the state should not adopt the emergency legislation internally. I only argue and I only think that declaring a state of emergency under Article 15 of the European Convention on Human Rights is not necessary. And I know that, well, and Bashak very nicely summarized that a big number, a serious number of contracting parties to the convention have already done so, and I see this practice as concerning and problematic. I think that those who argue in favor of Article 15 are really coming from the good place. And they really want to improve human rights protection. But I think that we all see and we all understand derogations under Article 15 quite differently. We all see it from a different point of view, and let me just explain my argument. In another webinar on the issue of emergencies organized by Binnum Center, Murray Hunt, I think, made a very interesting point at some point. He said that if the state declares the state of emergency, the politicians and sometimes the general public might think that at that point they can start ignoring human rights provisions almost entirely. And this is the consequence that I'm very much concerned with. Ideologically, Article 15 derogation might lead indeed to more draconian measures than those adopted without Article 15 derogations. Of course, we don't have an exact comparative case. Then we would need exactly the same country to look with Article 15 or without Article 15. But this is not a far-fetched argument to contemplate. And of course, in these circumstances, in 5, 7, 9, or 11 years, we will find out from the judgment of the European Court of Human Rights that these measures were not proportionate. But that, and I agree with this on that point with Alan, that this might be a little bit too late, you know. So that is how politicians can see derogation as a carte blanche to limiting human rights. Supporters of Article 15 derogations, like my learned and good friend Alan Green, obviously see Article 15 derogations as a magic tool, as a magic bullet that would ensure that the state makes the derogation temporarily, you know, within particular time limits, and then they will go back to normal. And this is only because Article 15 derogation was made. I don't think that this will happen. Of course, we will need to wait and see, but I think that the impact of Article 15 on those events will be quite peripheral, especially when we're talking about exiting, leaving emergency. Article 15 itself does not textually require that emergency is limited in time. And the case law of the European Court of Human Rights is quite unclear on that point as well. So that is how supporters of Article 15 see that derogation and what they think it will do. And finally, let me tell you how I see emergency, and in part we overlap with supporters of Article 15. Of course, everybody knows and everybody understands that there are rights which cannot be derogated from, irrespectively of emergency. Article 2, 3, Article 4, paragraph 1, etc. So technically, they will not be affected by the declaration of derogation in any case. Yeah. In relation to all other rights, the court uses a two-step test when analyzes emergencies. First, the court considers if the measure at hand is proportionate under normal situation, under normality. Yeah. If this is not the case, and the state declared emergency, then the court will consider if the measure is strictly necessary under this emergency, if it is relevant and directly linked to it. So the added value of Article 15 in this analysis is rather limited. I will show you why. Martin Scheinin, in the blog post that has already been mentioned, made a somewhat similar argument. Under the normal proportionality test, the public health emergency will be taken into account. Moreover, when emergency will be over, it will also be taken into account. And those measures that are considered appropriate during the pandemic will be considered excessive after the pandemic. So the proportionality, it of course depends on the article that we are talking about and the specific circumstances of the case, but the proportionality analysis already takes into account much of what Article 15 can provide for. So you don't really need Article 15 derogation to apply this sort of analysis. Proportionality already takes care of that. Another aspect of the same issue, and I think David Milner from the Council of Europe during the same webinar and Kustrimis Trefi separately, they argued that the Council of Europe might use other ways of supervising over emergency, except other than the European Court of Human Rights. Yeah, but again, to do that, Article 15 derogation is not necessary. The Parliamentary Assembly of the Council of Europe can initiate supervision without any reference to the state of emergency. One can also recall an often forgotten right of the Secretary General to request explanation under Article 52 of the Convention. But here too, you don't really need the state of emergency. What you need is a political will from the Secretary General and the state support to what the Secretary General is willing to do, right? These are all political issues, and Article 15 is not, strictly speaking, necessary to do that again, right? So, yes, of course, we are living in the state of emergency. And adoption of Article 15 or not adoption of Article 15 will not change that. You cannot obviously turn an apple into an orange by passing a legal act to that effect. You know, the same applies to emergencies. The states do pass emergency legislation, but hopefully that the most of the measures adopted by the legislation, or some of them, will fall within the framework of proportionality. Those which don't fall within the framework of proportionality are the violations of the convention. And most likely Article 15 will not change that unless we are in a very, very narrow segment of cases. We all understand that the states now are under enormous pressure. Yeah, they have a lot of positive obligations, as Natasha absolutely rightly argued and pointed out, and they need to come up with effective measures to protect health and well-being of the people. Yeah, often they need to do that in circumstances of lack of clarity of what's exactly going on. Human rights law already has internal mechanisms that do not prevent necessary measures from taking place. They can use these mechanisms. Having said that, if a state uses the emergency to usurp or to capture, to take more power than necessary, and for example, silence the opposition, stop any gatherings which cannot be linked to the issue of emergency, etc., then no formal state of emergency can cover that up. This is a bad faith application of the convention, and this bad faith application of the convention will be dealt with by the European Court of Human Rights, hopefully, under the framework of Articles 17 and 18 of the convention, which ensure that the states are responsible for such abuses of rights. And there again, no Article 15 derogation can change that fact. So, to wrap up, and I think my 10 minutes are over or almost over, just in 2 sentences. I think that the real life effect of Article 15 will be limited, as I can show, as I have shown, but ideological consequences might be considerable. That's why I think that formal derogations will cause more harm than good. Thank you very much, and I'm looking forward to answering questions, comments, and everything. Thank you.
Thank you very much, Konstantin, and the shaking camera for emphasis was particularly beneficial. I think we really got the point rammed home as a result of those. So we can open things up to questions now from the audience, if anyone would like that. If anyone would like to contribute or comment, any of the panelists would also like to take issue with anything that other people have said, that will also be completely fine. So comments, if anyone would like to pitch in, please make yourselves known. We have a question from Bruno. Bruno, I am going to put the spotlight video on you. You are muted at the moment. Let me unmute you as well. Oh, sorry, that's the wrong person. Now, Bruno.
Hi. Just a question on the comparative perspective. It was really interesting to look at the factors that might explain why some states derogate and others not. But one thing that is puzzling to me is that some states have made a derogation, a formal notification for the ECHR, but have not made the same declaration for the ICCPR. So I'm wondering if there's any explanation. So some have, I think Georgia and Armenia have made, and Estonia, I think, have made both, which I think is sensible, but I think there are 3 states, so I have them here. North Macedonia, Moldova, and Albania, I think, have only made the ECHR derogation, but not the ICCPR. So I have a hard time explaining why. So I would be interesting if you have any thoughts about this.
Okay, no, that's a very interesting point, Bruno, there. So we're seeing, as you correctly point out, that we have some derogations from some states in the ECHR, others not from states in the ECHR, and they're not derogating under both treaties simultaneously. It may be, I think one of the possible reasons for that is that they may fear the repercussions of not derogating from the ECHR more than they do from the ICCPR. But over to the panel, does anyone on the panel have any comments to make on this? I see Ed has got his hand up, so I will ask Ed to make a contribution. 1 second, Ed, I'll just unmute you there. Go for it.
Sorry, forgive me, it's not a comment in relation to the last contribution. Perhaps it's a question I can put to those who may be interested in it, which could be scooped up with the last contribution. So I'm in terms of the Konstantin and Alan's tug of war, and very impressive, both sides. I'm persuaded by both sides, if that's possible. And I can see both sides of the arguments, perhaps much depending on the good faith of the state concerned being critical there as to whether they will abuse their chance to make a derogation. My 2 points concern this, though. These powers, say under the English model, contains a broad sweep of measures. Aspects of it may require a derogation, aspects not. What's a state to do in those circumstances? Presumably it's a kind of precautionary derogation which defines those aspects which are derogable. First point in relation to it. The second point, fascinating though the discussion is between Konstantin and Alan as regards the pros and cons of pressing the Article 15 button, the policy issues concerns. I'm wondering actually, over and above that, actually Article 15 sets a legal test on whether you derogate or not. That's complex, but I wonder if it essentially comes down to what was said in the Greek case all those years ago in the late 60s by the Commission. The third step in its test was whether, quote, the normal measures permitted by the Convention for the maintenance of public safety, health, and order are plainly inadequate. Are the normal measures plainly inadequate? If they're not capable, therefore, of covering the matter, you derogate. There's a legal test for derogate. That decides whether you derogate or not. Fascinating, very valid, relevant, though the kind of policy for and against arguments are. Thank you. Okay,
yeah, a really interesting point there. I'm going back as typically in Ed's style to historical precedent there of the Greek case way back. But yeah, I think that aspect of whether or not the measures are actually adequate under the existing legal framework should be one of the things that they take into account in the exigencies of the situation. Would any of the panelists like to take up that issue or one of the issues raised? Alan, we'll go over to you. There we go. Do you want to try the audio?
Yeah.
Go for it.
Yeah, can you hear me? Yeah. So I think, with regards to Bruno's question, I think you're probably correct that they fear the ECHR more than, say, the I suppose more implementation rather than enforcement mechanisms of the Human Rights Committee and the ICCPR. With regards to Ed's question about the legal test being if the normal measures are plainly inadequate, absolutely, yes. That's the trigger mechanism for a state of emergency. You're saying that the ordinary constitutional parameters or human rights parameters are limiting or impacting your ability to deliver an effective remedy, an effective solution to this crisis. So you are derogating precisely because the ordinary parameters are the problem. The issue with this, however, is then whether the normal measures are plainly inadequate or not is incredibly contestable. It's unclear because we've got so little jurisprudence in Article 5.1e. And I think this kind of feeds into, so Professor Martin Scheinen's blog talked about basically what can be done under the framework of permissible restrictions should be preferred. If those available options prove insufficient during COVID-19, then it is better to derogate than not to derogate. And I think that is a restatement of the principle in the Greek case. My argument is because what is normal or what normal measures are permissible is contestable, we shouldn't interpret those to allow or to say that what is happening now, these what we'd all consider to be exceptional powers, are absolutely compatible with the ordinary parameters of the Constitution or of the Convention. So yes, I think I agree with you. Yeah, it is that test. It's just because we disagree upon what those normal measures are. That's why we are where we are, I suppose. Thanks.
Okay, I've actually unmuted all of the main panelists, so I understand that Basak wanted to contribute there, and as did Natasha. So Basak, I believe you were first, so if you'd like to go ahead and make the contribution that you were going to.
Thank you. I wanted to make two contributions, one in relation to Bruno's question. I think it's helpful, why states have derogated from the ECHR, but not from the ICCPR. Or it's the same in Americas, actually. They haven't really done both, is the optional nature of derogation. I mean, the derogation regime is an opt-in regime, and it's an opt-in regime individually, or it doesn't say you have to opt in from all the things that you could derogate. Also have a look. I mean, a lot of these states that derogated from the ECHR haven't derogated from the European Social Charter. So even within the same regional system, you have these inconsistencies. But I think as international lawyers, we know that states are inconsistent. I mean, there's lots of evidence. But I wanted to just make a separate comment about this. I think Konstantin called Article 15 the magic bullet. That's how he charged Alan's argument, that this was some sort of a magic bullet. So I'd like to return that bullet back to you and say that your proportionality, the word that you use, your infamous proportionality, seems to be your magic bullet, Konstantin. I mean, I think we really need to unpack that. The proportionality analysis in a state of emergency versus proportionality analysis in a situation of normalcy are not the same kind of proportionality analysis. The normalcy will require a concrete proportionality test. So if I go to the park and I'm 3 meters away from somebody on a nice morning and the police comes and pushes me around, I could say, what's your problem? What are you doing this? But if the police has powers to come and intervene because they were given powers to intervene, and the police pushes me around, he would say, if there were a state of emergency, well, I have these powers for 3 weeks. And everyone will be like, okay. And if I say, I was only 2 meters away from the other person, no one is going to listen to me. Whereas in a beautiful sunny day without the virus, somebody has to listen to me very, very carefully. So I don't think you can say that the proportionality analysis, the same one, really requires a concrete proportionality analysis, and the state of emergency attracts abstract proportionality analysis. Now, we can blame the European Court of Human Rights for not distinguishing these two tests. The court's proportionality analysis case load is terrible and doesn't make these distinctions, but let's not use proportionality as a magic bullet.
Mm-hmm. Okay, it sounds like things are heating up a little bit here. There's some magic bullets flying on both sides of the argument here. So, Natasha, do you want to come in with your comment? Do you want to contribute to that, or shall I let Konstantin reply, do you think?
I think my comment might be a little bit relevant to Konstantin's arguments.
Cool, go for it.
As well. I was thinking particularly about sort of the way that we're speculating about the limited concrete legal effect, or at least Konstantin was speculating about the limited concrete legal effect of an Article 15 derogation, and at the same time about the pernicious ideological consequences of triggering derogations under Article 15 of the ECHR. And I was thinking that when we speculate about, for example, how key institutions like the European Court of Human Rights are going to deal with an issue, and how differential sort of key institutions are going to be, I think what we need to remember is that actually we are part of the legal response. We are part of the political response. We are currently sort of, not to be hyperbolic, but those of us who are here right now are part of the process of holding states accountable in the context of whether it is a de facto or a de jure state of emergency. And we do need to take that responsibility seriously. We do need to take very seriously the ex ante role of human rights standards in delimiting the powers of the state, and also in demanding and making positive demands of the state, because we can determine, you know, what will be the effects and what will be the limits and the installations that we can impose on what the state does and can do to us, and the contamination potential of what it does and can do to us. And just to add to that, I think that one really important angle that we haven't necessarily highlighted sufficiently today in terms of how we need to act proactively to address what is being done is, you know, especially talking about proportionality, is what Jeremy Waldron referred to as the image of balance that evokes, and the distribution dimension of a balancing act where particular harms are distributed disproportionately against certain communities and certain persons. And I was thinking especially about Ed Bates's tower block idea, the urban tower block. It kind of evokes a very particular distribution of the coercive dimension of state actions in the context of this pandemic. And I think we really need to be very, very vigilant and apply really stringent scrutiny in regards to the uncertain and potentially sweeping capacity of coercive institutions to particularly impinge on the lives of people who are already on the margins, who are already dispossessed in other ways within the state.
Yeah, so Constantine, do you want to reply to that? We also have a question from the floor from Alison Harvey, which we're going to get to just after that, but I assume you have some more bullets to shoot back in this argument.
Yeah, well, yes. Well, I don't know about the bullets, but let me discuss this proportionality idea. And of course, I agree with you that like we need to look into abstract review more when we discuss emergency measures. But like if I take the example that Bashak just brought to life about the park and a couple walking around the park and the policeman tells them to go home. Now, what would the European Court of Human Rights do in these circumstances? First, it would look whether the policeman has power, the legality step. And not every sort of law would be seen as legal from the perspective of the European Convention on Human Rights. And of course, the court looks into abstract legal provisions, and there are plenty of cases about that, starting from bedroom tax legislation. The name of the case escapes me, but like the European Court of Human Rights looks whether abstract laws are in compliance with the European Convention on Human Rights, and whether this particular issue was proportionate to the pandemic that we are facing now. And the court will have to say, and that's exactly how the governments need to look into that, is that proportionate? So we have people getting ill and dying. That is how the virus is spreading. So what measures would be directly relevant to this issue, and what measures would be useful in that case? And this, of course, it is a legal fiction. Like there is no balance in stricto sensu in that exercise. But we need to see kind of like approximate similarities between the measures and the outcomes that we were talking about. So I think that proportionality is a good way of doing that. But like my main point is not about proportionality. My main point is about that Article 15 doesn't add much to that discussion of proportionality. Thank you.
Okay, so we have a question then from the floor from Alison Harvey. I'm going to unmute your mic, Alison, if you want to ask as well. We'll put your video up as well if you want to go for it. Then Jörg is asked to ask a question as well, I believe, so we'll go to him next.
I think I've put my video on. But
yes, you have. We can hear you and we can see you, yeah.
Okay. So I'm a barrister. I'm doing these cases in I'm having to make point very frequently that while proportionality is a relevant consideration in cases such as Article 8, proportionality is not the test under Articles 5 and 2. My particular concern is persons already deprived of their liberty, so people in care homes under deprivation of liberty orders, prisoners, people in immigration detention. I do not think that you can use proportionality to justify what I'm seeing on a daily basis, which is people having to die alone because family are not allowed to come in to see them. Proportionality won't get you there. It doesn't work for all articles. And these are not normal reactions to an abnormal situation. They are extreme reactions that a state would not normally claim to have the power to use. Thank you.
Okay, thank you very much, Alison. Would any of the Constantine, do you want to come in there?
Yeah. Just very, very briefly, I completely agree with you that proportionality should not be at least the same type of proportionality used under Article 8, 9, 10, 11 cannot be used in relation to Article 5 or 6. That is not my argument. The thing is that I agree with Alan that under it depends what sort of limitations we are talking about, and if there is a limitation that's gravely undermines rights under Article 5, it will be a violation, and no Article 15 derogation will change this thing. So I'm not in favor of limiting human rights protection. I think I'm in favor of upgrading the human rights protection in that sense. So like when you derogate under Article 15, there will be more scope for an argument that the state had emergency legislation to limit Article 5. You know, that is exactly the case. This is exactly the case in I think Bronigan against the UK case, where a lengthier time under Article 5 was considered appropriate, while if there was no emergency, this wouldn't be the case. So emergency gives the state slightly, but more leeway. Now, and obviously, I didn't tell that the same type of proportionality test should be applied to Article 5 or Article 6. No, don't get me wrong, and I need to make this sort of footnote very clear now. Thank you for your question.
Okay, yeah. So I think one of the issues that the panelists haven't really touched on, which I think might be relevant for them to comment, is the degree of the margin of appreciation that will come into play here. Because I think traditionally the European Court of Human Rights has been incredibly deferential to states in the context of derogations in general. And in that context, I guess that will kind of lean towards what Constantine is alluding to there, that the added value that could come from having a derogation in place here might not actually really be worth it in the end because of the degree of deference that the court would actually give. Do you have any, the panelists have any responses to that issue?
Of course Alan would have.
Go for it, Alan.
My simple response is that deference happens with or without an Article 15 derogation. And it's exactly my concern that deference is going to happen without an Article 15 derogation, which is why I'm in favor of it, because you are going to get bad jurisprudence. So we need to quarantine that jurisprudence. Mm-hmm. I don't have a lot, I like human rights, I like the court, I don't have a lot of faith in the court. You can see it in all its Article 5 cases. You know, you look at cases like Bagal, you look at cases like Gillen, the court will not engage with the Article 5 issue for some reason that I cannot see why they think Article 8 should take precedence over Article 5. There's no jurisprudential reason why they would do that. It's a purely political issue why they don't decide the Article 5 thing. So it's precisely because, and you know, that's deference by any other way. Using the avoidance doctrine, the admissibility criteria is another form of avoidance. So margin of appreciation, all these other forms of avoidance, I think are quite problematic. And when the case finally does come to the court, they can't avoid it anymore. You get this, you know, deference, margin of appreciation, for want of a better word. So that's precisely why I'm in favor of Article 15 rather than against it.
Mm-hmm. Yeah. So Bashak, do you want to come in there? I think Natasha wants to as well. So please go ahead, Natasha. I'm trying to unmute you, Bashak. Sorry. Go for it. Yeah.
I'll leave it over to Bashak first.
Thank you. No, my point is going to be really short. It has to do with the fact that now 9 states derogated, and what does it give us? What is it? 38 states haven't, or whatever it is. Did I get the math right? So anyway, but we are in this unusual situation that everyone is facing the same problem, and some have and some haven't derogated. So the question is going to be, if there are cases from those that have derogated and those that haven't, what is the European Court of Human Rights is going to do? Is it going to say, oh, you have derogated, but I will treat it as if you didn't? Or is it going to say, you haven't derogated, but I will treat you as if you did? So I think this is a different problem. And it is a problem about margin of appreciation as well. The state practice is going to put the court in a very strange situation of what I call this variable geometry. And it will be incredibly complicated if they were doing different things in different places, even though the facts are actually exactly the same. So that was cool.
That's a really, really excellent interjection there. And I think what you mentioned about Hassan versus the UK really comes into play in that context, where they're kind of coming up with these implied derogations to Article 5 that roll along in there and saying, okay, well, we're just going to pretend as though you did that. So Natasha, do you want to make a comment there? And I think Ed would like to after that. So go ahead.
Thank you so much. Just fairly quickly, I think there is a really real risk that the margin of appreciation will be expanded, particularly in the context of what Bashak has highlighted to be quite a divergent set of state responses to the pandemic. We know that when there is dissensus or divergence, the court feels inclined to accord even more latitude in particular issues. But I think that one thing we learn from, for example, the counter-terrorist context of emergencies and similar, is that it does matter also the sort of creativity and vigor and rigor shown by lawyers arguing cases in domestic jurisdictions as well. So, for example, in the Belmarsh case, it was also the domestic outcome that kind of spurred quite a good judgment in the UK by the European Court of Human Rights. And so I think that it is really vital for, in these dark times, for lawyers to think quite creatively and to argue in the strongest terms possible across various dimensions of the human rights implications of coronavirus. And to respond to Alice and Harvey's point, I think that in the realization of the right to life, the non-discriminatory dimension is going to become quite important in these very strange and challenging times in terms of the healthcare provision that persons in care homes are receiving, for example. And additionally to this, the dignified experience of coronavirus and indeed of dying of coronavirus, I think is going to become a really important dimension of potentially arguments under Article 3 of the European Convention on Human Rights. And I think that this kind of thinking is going to be significant before we get any outcomes at the European Court of Human Rights level.
And of course, the aspect of discrimination is one of those threads that runs through derogation systems across the way. You always see different categories of people that get discriminated against, whether it's, Catholics in Northern Ireland, Kurds in Turkey, Muslims in the UK, all of those things, derogations, they seem to generate these kinds of issues as time goes on. I believe we have a comment from the floor. Can we just hold off on your interjection? I believe Jorg has wanted to ask a question for quite some time, so I'm just going to go to you, Jorg. Would you like to would you like to make your comment there?
Hello, can you hear me?
Yes, we can hear you. Thank you.
Okay. No, many greetings from Strasbourg. Many thanks for organizing this very interesting exchange. I think academics will have to say a lot about this crisis and how it will be dealt with by the court. And I think we need also this critical feedback in Strasbourg. And I just two or three short comments or questions. You have seen, I think I would agree with much that has been said in particular by Bashak, that there is not a consistent use of this derogation powers, but I think it's really simply due to the fact that the national legislation in the countries is so very different. You have countries that have this tradition to derogate, others not. And certainly you cannot say in Strasbourg, we neither encourage nor discourage derogation. I think it's really the decision of each member state to do so. And what the Committee of Ministers has underlined, and I think this is a bit in the sense of Alan Green also, that the derogation is part of the system and is in fact an important feature of the convention, because in a certain way permits the system to function precisely in a state of emergency. And so I think there's whether to derogate or not is really the decision by each state. And on Article 52, it's true the Parliamentary Assembly in particular argued that this provision should be used by the Secretary General, but you should also be aware, and probably you are all experts, you are aware, that this has not found much consent or appreciation, neither in the Committee of Ministers, nor there's also comment by the legal advisors, the CARD committee, which found quite... Personally, I must say, I have also a lot of sympathy with this view that in the context of Article 15, there is really not much room to use Article 52, which is essentially a preventive measure. One can even ask oneself whether this provision has really still, it's a bit a derelict from the time, has still much scope, because it's a derelict from the time there was not the compulsory jurisdiction of the court. And I think also recent usage of this Article 52 was not particularly successful, to put it mildly. And this possibility, I find this under. I think this is something to be much more examined and discussed about. I think we are really in a very special situation. I think this current crisis, I think it's clearly unprecedented in the sense, I mean, you only have to look out of the window. I mean, the way, the extent to which basic fundamental rights are almost annihilated. We have practically in most countries, even very democratic countries like Germany, France, we have freedom of assembly, and practically the commercial activity has come to a standstill. So we have such draconian measures, but all based, and I think this is very important, one should also, what is really the good we protect or states aim to protect? I think it's not directly the right to life. If it were this, you should also, for example, prohibit motor vehicles, road traffic. I mean, we accept that people die because of road traffic. But here we have this, what is really the specific goal that the measures pursue is to allow a capacity-based management of the pandemic, to ensure that enough space and is available in the emergency wards of hospitals. I think it's, of course, a very important good, but it's all based to a large extent on prognostics, on forecasts. And so this makes this situation so special, I think. And we should be very careful, and we need this of restrictions, because even now government have not a very, even today is not unanimity among experts about the exact origin of the pandemic, the exact way how just now in Germany was published a major research into a case outbreak, which showed apparently that in the end it's only very close physical contact which allows the spread. Any, for example, this will allow not sit in the park, it's clearly unproportionate. Where do you allow someone to walk but not to sit? This kind of thing. So I think one must be very careful in this context to strict limitation, to check on the basis of evolving and scientific and the constant search for milder means also when we go out of the pandemic. It's very different, I think, from all the traditional threats like terror, I think it cannot be so much compared. But let's see. Thank you.
Well, thank you very much for that interjection, Jorgen. Apologies for the delay in getting to you there. So can I go back to our panelists then for any responses that they may have to the comments that Jorg has made? Oh, sorry, Ed, actually, I believe you wanted to make a comment. Sorry, no, okay, you're all right. Would anyone like to respond to those comments at all? Natasha? Oh, no, I think you're still muted. Hang on, let's... oh, no, sorry. We're unmuting, remuting. Okay, go for it. I think we can hear you now.
Thanks. It's just a brief response. Thank you very much, Jörg, for your comment and questions. I think even though I advise caution about how the duties to protect life are being invoked to justify quite extensive coercive measures, I would still say that it does make sense to speak of positive obligations to protect life as shaping certain initiatives, including the lockdown measures, alongside sort of the efforts to manage the capacity of the healthcare system and the state more broadly in the context of this pandemic. But I think the point about banning traffic is a really interesting one, which I think affirms my legality limitation argument, that I would argue that some traffic rules and regulations are actually means of protecting the right to life, as well as, of course, managing human interactions in vehicles, but they do not extend to measures that would be essentially unlawful within the scheme of the European Convention on Human Rights, and that would restrict liberty, therefore, in an undue way under the European Convention on Human Rights. And then on the extent to which this situation is comparable to the counterterrorism context, yeah, I think we ought to be cautious about drawing too many parallels. But at the same time, I think that we can learn some lessons about sort of mobilization, including the mobilization of key institutions, key actors, and civil society in order to hold states accountable effectively when other processes might be too slow or too deferential to do that.
Okay, excellent there. Thank you for that comment. I believe Ed wants to make an interjection there. Do you want to say something, Ed?
Thank you. Can you hear me?
Yes, absolutely. Go ahead.
I had kind of a number of points stacking up, if you forgive me. First of all, Jorgen, the variable approach across states, and this has, of course, been mentioned by others. I think I agree. I'm not entirely surprised that there is a variable approach. I wonder if one aspect of it is, to some extent, states are still waiting to see what the unfolding picture is, to what extent they really need to rely on certain powers, etc. That there's a lot of unknown still yet in terms of the extent of power they need to resort to. And there one needs to bear in mind that as the situation evolves, states should be alert to the fact that the situation may change. And yes, indeed, they do need to derogate if they want to take a certain action. The next point I would make concerns the preceding discussion about margin of appreciation and a concern that Article 15 will land us in a world when there's too much margin of appreciation applied to a given state. Actually, I wonder if we're being too pessimistic there, bearing in mind that the time the court actually hears this will be several years down the line when, God willing, most of this will be over, if not all of it. The previous case law, particularly on margin of appreciation in relating to the strictly required by the exigencies of the situation, Article 15 case law, has concerned entrenched emergencies, terrorism scenarios, some of which have lasted decades. And so this is a different scenario, and I'm wondering if the context will change the approach the court may adopt there to margin of appreciation. I don't know, of course. The last point I would make is actually, the need for this to be litigated through domestic legal systems. But what the discussion brings forward the need for a kind of European answer, a convention answer on this. And that makes me think of the advisory opinion procedure for Protocol 16. From recollection there, of course, that requires a senior court within the national framework to make a reference to Strasbourg to ask a question that's before it. Of course, the UK hasn't ratified that protocol either, unfortunately, and only a relatively small number of states have. But it's a classic scenario here, to me, really does reveal something in which we may look for European guidance on from the Strasbourg Court, and really underlines the need, therefore, I suppose, for an effective advisory procedure as well. Thank you.
Can I jump into this issue of advisory opinion just for a couple of seconds?
Sure, go ahead, Konstantin. Yeah, you have the floor. Go for it.
Thank you. Just very quickly, I think, well, I've been always very skeptical about this advisory opinion procedure, and I doubt that the courts will be able to provide an abstract solution to very multifaceted and difficult situation like this. So I'm very skeptical about the effectiveness of advisory opinions in general, and the first one kind of underlined my skepticism, and I am very skeptical about the fact that the European Court of Human Rights is legitimate, and it is possible to issue an advisory opinion that would be one solution that would fit all the states.
Can I add to that?
Yes, please, please do, Ed. I'll just
does that still apply, for example, if there was a case on what are the legal parameters to Article 5.1e in terms of last resort detention in the context of this?
Yeah, I think that would be a paradigmatic example of when it would be quite useful, I would expect. Yeah, so Konstantin, do you have anything to respond to that?
Point on Article 15 overall, yeah.
Okay.
On the Article 15 point, the court would not want that hot potato.
I guess the issue here as well is that we're facing a situation where everyone is confronted with the same emergency, as Basak was kind of alluding to earlier. And in a sense, it kind of reflects somewhat the inadequacy of like these single case-based approaches that we have at the European Court of Human Rights, and that there might be a possibility or a need for reform that would address those kind of limitations of the system, where we can have a more blanket approach to it, where there is a blanket emergency. I mean, unprecedented times call for unprecedented measures. I mean, it is unusual in that sense, in the sense that when we've looked at other things, the emergencies have been quite localized, or in any sense, the reactions of different states to them have been quite localized. For example, with the UK derogating in the context of 9/11, but other states not doing that. Basak, do you have anything to add to that, or do you have any kind of comments that you would add in that context? Sorry, can you? Oh,
myself.
Go for it. Yeah, sorry.
No, I mean, I think maybe going back to the beginning, in a way, of our conversations, we all recognize how unusual the circumstances are at the individual level, at the community level, at the European level, and at the global level. I mean, it's right there. And I think for the European Convention system, for the derogation system, it is exactly that. It's a very unusual and a collectively shared moment that does require some thinking. I have to say, I do appreciate, when we go back to the old cases, the lawless and the Greek cases, and of course there are some really important sort of clues in the case law. But I think almost that we need a bit more of a forward-looking thinking, and I think it is really an important time to think comparatively, and we can't just look at a particular jurisdiction any longer. And strangely enough, we're all stranded in some room or another, and we're able to follow what's happening around the world. So I'm kind of pleased about the derogation statements just from that technical perspective. I don't want to open that debate again, but we're able to download and read these things. Not that everyone is going to do it. It's just a few handful of us and our participants who may be able to do that. But it is unusual that we're also able to access more data, and I think that will allow us to think further on these issues.
Okay, thank you very much for that interjection there, Bashak. I think we're coming towards the end of the panel for today. So if anyone would like to make any final comments on our panel, or if anyone would like to ask a final question for the panelists, you can make it known. But I'll pass over to the panelists just to give the opportunity to others who are attending if they'd like to ask. Would anyone here like to make any final comment on the situation or the panel overall?
Just stay healthy, everyone.
Stay healthy, yeah, absolutely. In that case, since I don't see anything occurring in the live chat, I'd like to thank all of the participants for coming along today. I'm sure you've had to clear your schedules to get here, and it's been quite a trip for a lot of you from maybe the living room or the other office to get here. So much appreciated for taking the time to do that. And thank you as well to Constantine in particular for arranging the Zoom. Apologies for some of the issues in terms of capacity. I think this is more popular than we expected it to be, but I suppose we shouldn't be surprised with such wonderful panelists and such attractive people, generally speaking. So we will leave it there. I'd like to thank everyone for coming, and thank you. Stay safe, stay healthy, and we will see you all very soon.
Thank you very much.
Thank you, Stuart,
Bye.
for your
Thank
time.
you. Cheers. Bye.
Thank you. Thank you. Bye.
Bye, everyone.
Bye.
Bye, everyone. Thank you.
Thank you.
for joining us.
Thank you.
Bye-bye.
Okay. Oh, hang on. OBS needs to stop.